Hi everyone, and welcome to Psychology and Law. I hope you guys are as excited as I am about this course. So the first part of the semester, we are going to be spending our time familiarizing ourselves with the legal system and some of the key players in the legal system. And some of you might have experience with this, especially if you are in the criminal justice field. But then we're going to move on and we're going to spend the rest of the semester really delving into how science, and particularly psychological science, influences the law and the legal system. And this can happen in a lot of ways. And one of those ways is through influencing an actual case itself. And this might be, for example, through expert testimony. So you have an expert that comes into court and provides testimony regarding some type of issue that is relevant to a particular case. So for example, scientific expert testimony might involve an expert discussing DNA, whereas psychological expert testimony might focus something on dangerousness of an individual, or if there's a confession in the case, whether or not that confession might have been coerced. And another way that we can think about how science influences particular cases is through amicus briefs, and this term literally means friend of the court brief. And this essentially is anybody that wants to weigh in and provide an opinion to the court that they feel would be particularly helpful for a specific case. And later on, I believe on the next slide, we're going to discuss this in more detail. And then another way that science can influence the law and the legal system is through policy decisions. And so this revolves around the idea of essentially whether or not policies that we have in place or policies that we would like to put in place are really evidence-based or have data to support them. But it is important to keep in mind that science can't answer all questions related to policy and policy decisions. So a good example of this is when in this country we were deciding or trying to change the drinking age from 18 to 21. And we're doing this because we really thought that 18 to 21-year-olds maybe were not responsible enough, and that they might have been going out and drinking and then driving, so increasing this rate of drunk driving and really just making people less safe. So the rhetoric surrounding this was really, safety in the community and trying to decrease drunk driving. But there were sociologists who actually looked at the data, so data that revolved around drinking and driving patterns of young adults. And the data showed that the most DUIs were really received by people between the ages of 20 to 25. So really, at the time, these 18-year-olds weren't, quote-unquote, the most dangerous group, this 18 to 21. It really was this 20 to 25-year-old group, according to the data that we had on drinking and driving patterns of young adults. But if you think about it, that would have been a really weird policy decision to put in place, to say something like, you can drink from 18 to 20, but then you can't drink from 21 to 25, and then starting at 26 again, you can drink. So that's just to kind of point out that while there are a lot of ways in which data and science can influence policy, sometimes data in and of itself doesn't just lead to a good policy if you're just focusing on what the data show you. Next, I wanted to move back to what I had mentioned before about this amicus curiae, or this amicus brief. And as I mentioned, it literally translates to friend of the court, and it goes back to the idea of it goes back to ancient Rome. So an amicus brief really involves an outsider, so someone that's not part of the case, and it involves them filing a brief with the court, and this is because they have an opinion or some type of information or legal theory that is relevant to the case. And pretty much anybody can file one of these briefs. However, there is a fee to filing these briefs. So that can be a deterrent, and because if you're really creating a good amicus brief, it can cost anywhere between $25,000 to $30,000, because this is going to involve intense research and intense time by a lot of people to create this brief. However, a lot of groups in our society, such as the ACLU or the NRA, really, they want to file these briefs, and they do. If the case that's being brought to court has some type of issue that is relevant to what their organization stands for. And in a lot of high-profile cases, a lot of high-profile issues, the court can receive hundreds of these briefs. So one of the most famous types of briefs is what's called this Brandeis brief. And these are used most in social science or psychology. And this Brandeis brief stemmed from this man who was advocating to the Supreme Court regarding an Oregon law. And this Oregon law wanted to limit the number of hours that women could work in the laundry at the time. And what he did is he provided empirical data to the court in this brief that demonstrated that working these long hours had negative impacts to the health of these women. So this Brandeis brief is this idea of a brief that includes data and is backed by research and science and empirical findings. It's not a brief that just solely relies on, say, logic or legal theory. So this Brandeis brief is really going to be the type of brief that you're likely to see from psychologists. Next, I wanted to just touch on the fact that the APA, the American Psychological Association, does file a lot of these briefs. So I just wanted to quickly go to their website and just give you guys an idea of how many briefs the APA has filed, and, you know, some of the types of different issues that they weigh in on. So you can go through here. I've included the link at the end of the lecture if you'd want. And you can go see, you can access the full text of these briefs. But essentially, I just wanted to show you some of the topics and how often the APA files some of these briefs. So we see abortion, affirmative action, animal research, antitrust, battered women's syndrome, child abuse, child sexual abuse, civil commitment, competency, and just the list goes on and on. Death penalty, duty to warn and protect. So really, we have psychologists here from the APA and the American Psychological Association itself writing these amicus briefs to the courts on these issues that we, as a field, have particular knowledge on. You can see here, for example, false confessions, insanity defense. So yeah, really, the list goes on, and there are a lot of different examples of ways in which the APA has weighed into the courts. But the question really is, right, do the courts actually consider these briefs in their decision-making process? So sometimes the courts can actually get really overwhelmed by these, because as I mentioned, they can, on high-profile cases, they can get hundreds of them. So sometimes they don't really use them. In fact, one study showed that only 8% were cited by justices in their decisions. So justices said that essentially they really only used these amicus briefs in 8% of the cases. And the justices have the right to just completely ignore the brief. They have no obligation to have to include these in their decision-making processes. And because of this, because of so many being submitted to the court on these high-profile cases, and the fact that there really is no obligation for the court to really consider these when they make their decision, some people have suggested that this notion of amicus briefs has really gotten out of hand at this point. Next, I just wanted to touch on psychology and law. So this is, what we're going to be specifically talking about in this course. And I just wanted to, right now, mention the fact that those who study psychology and law really come from very different disciplines within psychology. So we can have social, developmental, cognitive, or clinical psychologists that specialize and focus in psychology and law. For example, social psychologists might have some expertise in research in things like stereotyping and prejudice and how those relate to the law and the legal system. Whereas developmental psychologists who study psychology and law might be interested in how the children interact with the legal system, such as when children might be eyewitnesses and how we interview them in terms of child suggestibility and things like that. Next, cognitive psychology is definitely relevant to psychology and law. Cognitive psychologists might study things like decision-making and how jurors weigh evidence in particular cases, or particular types of cases. And then finally, clinical psychologists. And clinical psychologists are going to enter the psychology and law realm, and in terms of things like NGRI, so not guilty by reason of insanity, or making a competency evaluation about whether or not a defendant is competent to stand trial. And lastly, I just wanted to touch on this idea of law in a changing society. So some people think that law is never changing, and that the law should be interpreted exactly the way that those who wrote it. So this would be something like an originalism perspective. And this is in contrast to a living constitution, which suggests that laws should be thought of in terms of the way society is at the time. So we're just going to watch a quick video here that kind of delves into the differences and gives you an idea of these two different perspectives of how to view law.
I think a lot of the time when people hear about judges interpreting the Constitution for the purposes of making a ruling, they tend to think that this is something sinister going on, like the Supreme Court justices are inflicting their will upon people by interpreting things in the Constitution. But this is a misunderstanding, because there's no way to read the Constitution without interpreting it in some way. What actually is jaywalking? Is it jaywalking if I just step my foot off the curb 1 second before the light turns green? We need to interpret the statute in order to understand what jaywalking actually is, let alone whether or not this person's guilty of jaywalking. Turns out pretty much everything is vague in that way. Given that we have to do some interpreting of these statutes, we're also going to need some guidelines or principles for what the interpretation should look like, how to do the interpreting. The idea that we should think about what the words mean to the common reader today is known as living constitutional theory. On this view, the words mean something today to people in a way that they might have meant something different 100 or 200 years ago, and that it's the current meaning that should have the most weight. There's some intuitive appeal to living constitutionalism, as it seems to match our intuitions about the way laws change, morals change, customs change over time. An example of why we might need a living constitutional theory would be that when the First Amendment was first written, the freedom of the press could only have referred to printed objects. Today, of course, we think of journalism broadly as including broadcast media and internet media, and there's no particular reason why we should limit constitutional protection of journalists only to print media in a world where broadcast and internet media are real things. Living constitutionalism allows for the evolution of our understanding of what media is to include the protections of media to modern-day technologies. Another way of thinking about it is the so-called originalist theory, in which we focus on the meaning of the words at the time that the statute was written. For example, the Eighth Amendment rules out cruel and unusual punishments. But this raises the question, what do you mean cruel and unusual? Today, many people might think that capital punishment is cruel, and therefore it should be thought of as unconstitutional. But at the time that the Constitution was written, capital punishment was fairly commonplace and was probably not likely to have been regarded as either cruel or unusual. Even amongst originalists, there's differences of opinion about what it is that we're focused on. Some people think that we should be more interested in the original meaning of the words to the authors. Others think that we should be more interested in the original meaning of the words to contemporary audiences. And both of these would be distinct from the idea that we should care about the intention of the authors. If we understand the Constitution as a document that carefully enumerates the government's powers, then we're going to have some kind of originalism to help it do its job.
Okay, so as you can see in that video, there really are these different schools of thought in terms of how we should interpret laws and interpret the Constitution. From my perspective, I believe that originalist perspective is a little bit too strict, and that we really should maybe take this more living constitutional idea in terms of considering the fact that society changes, and there's going to be things that happen in our society that they couldn't have thought of at the time of writing the Constitution. So things like that, for example, might be changes in community standards. If you think back to Constitution times, most of the well-educated people in our country really only had a grade school education. And you can compare that to standards today, in which a grade school education would be extremely minimal. Another example of this would be women's right to vote. You know, at the time, women were not given that right, but certainly nowadays we believe that women should have the right to vote. So it's just an idea that, you know, with these community standards changing, that our laws really need to change with them. Another reason why law in a changing society is important is because of increased scientific knowledge. So for example, we now know about DNA, and at the time, the writers of our Constitution did not know about DNA. So there was actually a Supreme Court case that examined whether someone could patent your DNA. So there was a woman who had cancer, and unfortunately she passed away, and the scientists wanted to patent her cells because they were working on a cure. And if you look at the Constitution, there's no specific guidance on DNA, but there is guidance, and the writers do talk about things such as privacy. So it's really about this idea of interpreting, how do you want to interpret that? And in this case, the Supreme Court actually said, no, you cannot do this. And then finally, we have a lot of technological changes that have happened in society constantly. For example, there was a case that revolved around the notion of cars and automobiles. So someone brought to the court the fact that if you hit somebody with your car, does that mean that you have to essentially respond and tell the authorities? And the reasoning behind this, the logic behind this, was that the Constitution gives us a right to not incriminate ourselves. However, this actually went all the way to the Supreme Court, and the Supreme Court said no. Telling the authorities about hitting somebody with your car is not considered self-incrimination, and that you, in fact, are obligated to do this. So here I just have the links from the lecture today in case you want to go back and view either those briefs or that YouTube video. So that was just really a basic overview here. So in our next lecture, we're going to be talking about legal dilemmas and some of these kinds of dilemmas that we face when we institute laws and policies in our society. Thanks. See you next time.